Hello all, welcome to week 8. This is our first lecture. This week we're going to be exploring the end of the 20th century and the beginning of the 21st century. The time period from 1940s to the 1960s and 70s was a time of social movements for civil rights for minority groups. Activism and protesting continued across the nation, but not everyone liked the feeling of turmoil and unrest that came with social progress. Richard Nixon argued there was a silent majority who wanted to see an end to the protesting and turmoil. He's referring a little more specifically to Vietnam, but a similar argument is made against feminism and some of the other groups that we've looked at. So the first slide is about the Equal Rights Amendment. It was originally proposed in 1923 in the 75th anniversary of the Seneca Falls Convention. The first one was written by Alice Paul, and it was called the Lucretia Mott Amendment in honor of Lucretia Mott. And it said men and women shall have equal protection throughout the United States and every place subject to its jurisdiction. The amendment was introduced in every session of Congress until it passed reworded form in 1972. Previously, it had been upheld in committee, so it would get introduced, but it would make it to the committee to discuss it, and it would never make it to a discussion by the full House. It's important that Martha Griffiths, who is a member of the United States of the House of Representatives from 1955 to 1974, kind of makes it her personal crusade to make sure that it actually gets a fair hearing. And it was reworded to say, Section 1, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Section 2, the Congress shall have the power to enforce by appropriate legislation the provisions of this article. Section 3, the amendment shall take effect 2 years after the date of ratification. So as I mentioned, Martha Griffiths files a petition to have it heard in the full House. The Senate tried to add some wording to the draft, and then it did not pass. But then it was put up again, and the House approved it on October 12th of 1971, and the Senate approved the identical version on March 22nd of 1972. In 1978 was the original deadline. They have 7 years for states to get the appropriate number of states to ratify it in order for it to become a constitutional amendment. And it did not get those. That was actually extended to 1982, and still 35 states had approved it, but it was short by 3 states. And there's still not an equal rights amendment in our Constitution. There was a lot of anti-ERA activism. Phyllis Schlafly was an anti-feminist, anti-ERA activist who worked against the ERA to stop it. She's actually pictured in the front of this picture. And there were also other groups, women who want to be women, females opposed to equality. And a lot of times they made religious arguments against equality, that men and women were not actually equal. They should not have the same rights and responsibilities within the Constitution. They took on activist efforts like baked apple pies for the Illinois legislature while they were debating the amendment. They hung signs on their baby girls that said, "Don't draft me." As you can see, they protested, they picketed, and in the end, in 1982, it expired, and it was never ratified by the final states. So another issue that came up in 1986 was Bowers versus Hardwick. The police came to arrest Michael Hardwick for failing to appear in court. They saw him with his male partner in a bedroom performing oral sex, and both men were arrested at the time because of the Georgia sodomy statute, which said a person commits the offense of sodomy when he performs or submits to any sexual act involving sex organs of one person in the mouth or anus of another, A person convicted of the offense of sodomy shall be punished by imprisonment for not less than 1 year and not more than 20. So the majority opinion in this case ruled that consensual homosexual sex was not protected and that the law was constitutional. The opinion was a 5-4. And this was a huge blow for gay rights at the time. Last week we talked about Stonewall. We talked about some of the victories of the gay rights movement. But this was actually really devastating because it basically said that even in their own homes, people did not have a right to consensual sexual acts. So then it's actually overturned in 2003 with Lawrence versus Texas. It overturns Bauer versus Hardwick. The police had come to John Geddes Lawrence's apartment complex because of a weapons disturbance complaint. He was found in the sexual act with another man, and he was arrested under the homosexual conduct law in Texas, which is a person commits an offense if he engages in a deviant sexual intercourse with another individual of the same sex. And the court overturns Bauer versus Hardwick. The court ruled that the law violated the 14th Amendment's due process clause because that clause protects a substantive right to personal liberty and intimate decisions. The court argued that this decision in Bowers, which ruled the due process clause does not confer a fundamental right upon homosexuality's engaged in sodomy, was misguided. Its emphasis was the right to privacy in your own home, and it was a 7-2 ruling, which was a really large ruling, and that was a really important piece in the gay rights movement. The Civil Rights Restoration Act was a bill designed to restore federal protections for minorities, women, the elderly, and physically disabled individuals. It required the recipients who received federal money to comply with civil rights laws in all areas and not just the program receiving funding. So previously, the idea of the program that was receiving direct funding from the federal government had to comply with those rules. And what the Restoration Act does, it forces the entire group, in order to receive funding, be compliant. Reagan actually vetoed it, claiming it extended the federal government beyond what it needed to be. And it was actually voted in over his veto. And while this is an act that still takes place, I think it's important to understand the concerns about large government and the conservative reaction during this time period. The Supreme Court overturns part of the Voting Rights Act. Some of you may be aware of this case. It's actually just rather recent. It was in 2013. It's Shelby County versus Holder. It requires that the Congress come up with a new formula for the areas that needed special scrutiny. So you'll remember when we discussed the Voting Rights Act, that it came up with states and even certain counties in the north that were historically large African American populations, but had historically low voter turnout, and that was because of racism and African American votes. And what it basically does is it says that those formulas and ideas are antiquated and that the world has changed, originally passed. And it basically argues that Congress needs to come up with a new formula. The problem with that idea is that the proponents of the law, which protects minority voting rights, called the ruling a death knell, because it would be almost impossible for a Congress bitterly divided along partisan lines to come up with an agreement, they said. And so basically their point is that by saying Congress has to come up with a new formula, you've basically ruled it out completely, because that's not something that's going to happen at the time, because Congress is still extremely partisan and still having trouble agreeing even on simple things. And the Supreme Court, to their credit, did say that this is not a license for people to commit to suddenly make new rules about voting, but honestly, that's exactly what happened. Many states introduced new voter laws after this that are considered discriminatory by some. So in conclusion, the late part of the 20th century and even the early 21st century introduced some more socially conservative ideas, and many of them led to a limit of civil rights. This is for a lot of reasons. Some are they don't necessarily believe in the same access, but also it's a debate about civil rights often calls for an extension of federal government to protect the civil rights of individuals. Whereas conservatives usually argue for a smaller government because they believe that protects the rights better. So this is my reference slide, and there's a lot about this week's topics if you want to check them out. Thanks, guys, and have a great week.